surrogacy. The law of surrogacy is one of those areas of law where the law is the same in Scotland and in England. In most other areas of family law, the laws are very different because Scotland tends to follow a more civilian approach due to its history, whereas England, of course, developed its own common law. But in this area of law, the rules are the same, the legislation is the same. So the proposals for reform apply across the United Kingdom. Once I have talked about that, I will leave 20 minutes or so, I hope, for questions and discussion at the end of this lecture. So, the governing legislation in the United Kingdom, and you'll see this on the right-hand side of the screen, there are basically three pieces of legislation, three acts of the United Kingdom Parliament which govern this area of law. The first and earliest is the Surrogacy Arrangements Act of 1985. And this piece of legislation, and I'll explore it a wee bit further in more detail in a minute or two, it basically, what it does is to ban commercial surrogacy. It's a criminal offence to organise surrogacy on a commercial basis. The second piece of legislation is the Human Fertilisation and Embryology Act of 1990, which created a regulatory body called the Human Fertilisation and Embryology Authority. And this is the body that in the United Kingdom licenses artificial reproductive medical treatment, any form of artificial reproduction, artificial insemination, IVF, all the other forms. It is regulated by this body. 1990 Act originally also dealt with the parenthood of children born through surrogacy. But all the parenthood provisions have been restructured and reworked into the third piece of legislation, the Human Fertilisation and Embryology Act of 2008. And that now is the current law that determines parenthood after surrogacy. We are likely in the United Kingdom to get a whole new Surrogacy Act, probably sometime in 2024 to 2025. We don't know the precise timeline yet. And I'll explain towards the end of this lecture some of the proposals of what might go into this new surrogacy law. So, the title of my talk is Challenges from the practice of surrogacy. Surrogacy happens, whatever the law says, and it has happened really throughout history. And the first challenge for any legal system is to determine, should surrogacy be legal or should it be a criminal act? The United Kingdom's approach is to make it a criminal offence under the Surrogacy Arrangements Act 1985 for any person, any third party, to negotiate a surrogacy arrangement on a commercial basis. In other words, for payment. And it's also a criminal offence to advertise surrogacy services. Now, it's important to note how limited this criminalisation is in the 1985 Act. It's exceptionally limited. It only applies to third parties. So the mother, the woman who becomes pregnant, is not caught by this act. The couple or other people who want to become parents and employ the surrogate, they are not caught by this act. It's only third parties surrogacy arrangements, surrogacy agencies that bring the people together if they do it for profit. And the profit issue is really important because there is in the United Kingdom 2 or 3 charities, voluntary organizations, non-profit organizations who act to bring people together who are looking for a surrogate and surrogate who's looking to offer her services. So long as the charity, and I've given the insignia of one of them on the screen, COTS, childlessness overcome through surrogacy, that's a non-profit charity. It is allowed to bring people together and to facilitate and advise them, but it's not allowed to make any profit for doing so. The Surrogacy Arrangements Act of 1985 was a very speedy, ill-thought-out piece of legislation. It was introduced in a hurry in 1985 due to a public panic over the issue of surrogacy. And at the time, in 1985, at that time, surrogacy was thought to be almost like prostitution and not something that the law should encourage. So what the 1985 Act clearly is trying to do is to discourage the practice, but it's important to note that it did not ban entering into these arrangements. And since 1985, the social and ethical concerns around the practice have very substantially reduced. They may even, in the United Kingdom, have evaporated completely. And the public perception today of surrogacy is very different from what it was in 1985. The Surrogacy Arrangements Act 1985 is still good law. It is still valid and enforceable, but it's, as I say, it's limited. It does no more than prohibit profit making by third parties making surrogacy arrangements. Given that the practice itself is not criminal, it's accepted to the law. Given that it happens, and whether formally or informally, surrogacy arrangements are entered into by couples who need some help in producing a child to create a family. Given that surrogacy exists and happens and occurs, the next challenge for the law is how should we regulate it? Now, here's the thing in the United Kingdom. Even although we have a regulatory body called the Human Fertilization and Embryology Authority, this authority was set up in 1990 by the 1990 Act. Even although we have a body, and this body is one that licenses the provision of IVF, artificial insemination, and all these other forms of reproductive technology, even though we have this body, it does not regulate surrogacy. It does not regulate surrogacy. It regulates it only indirectly, because most surrogacy arises when a pregnancy is created by artificial means. And I'll come back to that point later on. It's an artificially created pregnancy. And the Human Fertilization and Embryology Authority does regulate how the artificial pregnancy is provided by the medical profession. It regulates the medical profession, but it doesn't regulate the agreements that are entered into by the surrogate and the other people. There is some regulation in the United Kingdom through our charity law, because the agencies that we have in the United Kingdom, and there's a small number, 3 or 4 of them, they are all charities. But the charity regulator, it is really just, it is really focused on making sure the charity does not misuse its money or does not put itself in conflict with the law. Again, the charity regulator does not regulate in any way the agreements that are entered into by the surrogate and the intended parents. The only real regulation we have in the United Kingdom is through the criminal law, which I've already talked about. And the criminal law ensures that profit is not made. So this is at the moment the main regulatory goal of United Kingdom law, to ensure that profit is not made. If profit is not made, then everything else is left to the private arrangements of the parties. Well, given that surrogacy is more or less unregulated in the United Kingdom, other than the criminal law, and given that surrogacy does happen, the question, the next challenge is whether the arrangement should be enforceable. The intended parents and the surrogate enter into an agreement, and they maybe like to think that that agreement is a contract. But a contract, as we all know, is something that in legal terms is enforceable, so that if any term of a contract is breached, you have a legal remedy. You can go to court and ask for a legal remedy. With a surrogacy arrangement, it's not like that at all. It's not a contract. Now, the 1985 Act, the Surrogacy Arrangements Act 1985 Act, did not deal with this issue at all. It ignored the issue. However, in 1990, the 1990 regulations, the 1990 Act amended the 1985 Act by adding in a new section 1A. And that provides quite clearly that in the United Kingdom, no surrogacy arrangement is enforceable by or against any of the persons making it. So it's not a contract. You cannot go to court. You cannot sue. You have no remedy. The effect of this is that if the surrogacy arrangement goes well, and actually in the United Kingdom, most surrogacy arrangements do go well. They're successful. Everybody is happy. But you don't need law. You don't need courts when everybody is happy and when everything goes well. You only need the law when things go wrong. And the problem with surrogacy is that, or one of the problems, is that when things go wrong, things go very, very badly wrong. And surrogacy, the practice of surrogacy, because it's unregulated, because there is no remedy, the practice of surrogacy is at the moment actually very dangerous. It relies very much on the goodwill of all the parties. And so long as they have goodwill and everything goes well, there's no real legal problem, except what's relating to the actual child, which I will come on to. But if everybody is happy about the arrangement and it has been given effect to, there's no role for the law. But if it goes wrong, if the parties disagree, then there's nothing anybody can do about it. And the law will not help if something goes wrong. So if, for example, the surrogate refuses to give up the child is born, the surrogate decides to keep the child. The intended parents have no remedy. They cannot go to court and say, that child is mine. If the intended parents refuse to take the child, there is nothing the law can do. Or if the intended parents refuse to pay in money what they had promised to pay the surrogate. And remember, that's not caught by the Surrogacy Arrangements Act. It's not criminal to pay a surrogate. It's only criminal to pay the third party. But if the intended parents say, we will give you, I don't know, £50,000 once we have the child and they get the child, and then refuse to pay the money or pay less, the surrogate has no remedy. If the surrogate decides to terminate the pregnancy, or she miscarries, or she refuses to return what is paid, there is no remedy. The law says it's a risk that you took. And if the risk has eventuated, you, the individual, have to bear the risk. The loss lies where it falls. So surrogacy is actually, legally speaking, quite dangerous. Now, having said that, virtually none of these problems have actually arisen in the United Kingdom. The practice of surrogacy, even though it's unregulated, the practice of surrogacy tends not to create these sorts of problems in the United Kingdom because goodwill by each of the parties seems to be apparent. But of course, these problems are not entirely hypothetical. The risk is real, and you in Thailand will be aware, you will remember a case which made worldwide headlines, what we in the West tend to call the baby gammy case. You probably have your own name for it, but it's known in Britain and Australia as the baby gammy case. This was the case where the surrogate in Thailand gave birth to 2 children, and the intended parents allegedly would only take one of the children, leaving the surrogate with the other child who had developmental problems. And there was no legal remedy. This is at least one of the cases which I think I'm right, persuaded the Thai government at the time to pass new legislation in 2014 or perhaps 2015, your own law regulating the practice of surrogacy. And I'm quite intrigued by what the new Thai law is called. I think names can reveal something. And the Thai law is named in the English translation something like a law for the protection of children born by artificial means. The protection of children. This is the motivation of the new Thai law, and I think that it is interpreted in the light of protection of children. So in the United Kingdom, we haven't had cases like this, but they are real and certainly have a potential of causing real difficulties. So at the moment, our surrogacy law is very hands-off. If there's a problem, the law will do nothing about it to try to solve that problem. And that's quite a hard position for the law to take. As I said, in the vast majority of cases in the United Kingdom, the surrogacy arrangement goes well. It's given effect to exactly as planned, and the child is handed over from on birth by the surrogate to the new intended parents. And that sounds fine in practice, but of course, in legal terms, the status of that child is very ambiguous, because you cannot just, you as a parent, whether a mother or a father, you cannot just give your child away to somebody else. The law doesn't allow you to do that. And even if factually you can allow somebody else to bring up your child, the child is still yours. And if there's any problems later on, perhaps a succession issue on death, so there's an inheritance claim, the child is still yours. The only way in the United Kingdom to regularize the position of the child in cases of surrogacy, in any case in which a child is being brought up by someone not recognized in law as the parent, the only way that that can be regularized in the United Kingdom is by a court order. We need a court order. Because there's another rule in the 1990 Act, which I've already mentioned. There's another rule which says quite explicitly, it defines who a child's mother is. A child's mother is the person who gives birth to the child. And the mother can't just give the child away. She can in practice and in fact, but not in law. So you need a court order. Now, the obvious way of getting a court order is by using the adoption legislation. An adoption of children has been available in England since 1926 and in Scotland since 1930. So almost 100 years of adoption practice. To me, this was the obvious approach. If the surrogate has handed over the child to the intended parents, they have no relationship with the child in law, they should simply go to the adoption court. That would be straightforward, and it would have other beneficial consequences that I want to talk about later on when I talk about the international regulation of this practice. But adoption does deal with a different situation. Adoption deals with children. It was designed to deal with children who are already in existence. Surrogacy, of course, is quite different, because surrogacy is designed to bring children into existence. And that's a very different process. So the British government decided that that required a different type of court order. So a new court order was created originally by Section 30 of the Human Fertilisation and Embryology Act of 1990. And this new court order was called the parental order. Parental order. It's not, in my view, a very helpful term to call the order this, because it's meaningless to most people. But that's the name that we have given to this order. And it's now contained in Section 54 of the Human Fertilisation and Embryology Act 2008. Now, here's the important difference between the 1990 parental order and the 2008 parental order. The effect is the same. What you have to prove is the same. All the conditions are the same. But in 2008, the availability of parental orders was very substantially widened. Who had title to seek a Section 11 order, a parental order, was very substantially increased. In 1990, a parental order was only available to a married couple. In other words, only a married couple, a man and a woman, because in 1990, same-sex marriage it was not dreamt about. But in 1990, a man and a woman who were married to each other, they could arrange with a surrogate, make a surrogacy arrangement, obtain the child, and only they could go to the court and seek a parental order. If a surrogacy arrangement was entered into by anyone else, for example, a single person, or two men or two women, or even an unmarried man and woman who lived together but were unmarried, they could not acquire a parental order. They could go to the court and ask for an adoption order, but they couldn't get this new parental order designed specifically for the surrogacy situation. So that was the law in 1990, and I believe that this is effectively the law in Thailand today after legislation from 2015. I believe that surrogacy, the transference of parenthood and surrogacy is lawful only when it involves a man and a woman who are married to each other, who are the intended parents. So that was our law too between 1990 and 2008. But in 2008, even although all the rules were replicated, the conditions were replicated, the consequences were replicated, what was different was who could claim. Unmarried couples, people who were not married, same-sex couples, and same-sex couples, of course, in Great Britain can now marry. They were, after 2008, they were then able to apply for a parental order after surrogacy. It's even been open to single people who can apply for such an order. Now, one of the consequences of opening surrogacy in this way, or opening the parental order in this way, one of the consequences of this was that it became a very popular means of starting a family, of becoming parents for gay men, same-sex couples who were male. You see, same-sex couples who are female same-sex couples, they have most of what it needs to become parents. All they need is a donation of sperm from the man. And frankly, the world is awash with sperm. There's a lot of it around. It's very easy to obtain. So female same-sex couples always had their own ability with very little effort to create children and become parents. Male couples, on the other hand, require very much more. They require not just the genetic material of the female. They also, of course, require a womb. They require a woman. They require a woman to give them 9 months of her life. So it's a much greater thing for a much more difficult thing for same-sex male couples to become parents than for female. And the 2008 Act suddenly opened up this opportunity, and it is an opportunity that has been taken very, very vigorously in the gay community in the United Kingdom. And the photographs on the right of this screen, this is the two photographs of celebrities. The one on the left, of course, is Elton John, the famous world famous singer and pianist, showman, him and his husband and the 2 children that they became parents of through surrogacy. The photograph on the right-hand side, that is Tom Daley, who is a British Olympic gold medalist. He and his husband acquired a baby last year, I think, through surrogacy. So we have these celebrities publicly engaging with surrogacy and producing very happy family photographs. And the effect of this, the effect of both the 2008 Act and the engagement with surrogacy and the public engagement with surrogacy, the effect being that people in the United Kingdom do not worry about the problems of surrogacy or the ethical difficulties of surrogacy in the way that they did 30 or 40 years ago. So it's been very important development in shifting public opinion, public perception of surrogacy. So that's how we do it in the United Kingdom. We make the intended parents go to court and ask for a parental order. Now, the parental order has exactly the same effect as an adoption order. What it does is to transfer parenthood, legal parenthood, from the original parents, which is the woman who gives birth, potentially her husband, to the intended parents who have entered into the arrangement with the surrogacy. So it's the legal effect of a parental order is identical to the legal effect of an adoption order. But the parental order achieves this transference of parenthood without any state involvement other than the court. It does so without what the adoption legislation demands, which is very detailed investigation and background checks into the suitability of the parents. None of this happens with the parental order. It's a much more private arrangement than adoption. There are a number of conditions that have to be satisfied before the court will make a parental order in the United Kingdom. And my next few slides will explain what these conditions are. And I think they're interesting as revealing the policy objective, the way that our politicians look at surrogacy, and also they're very useful in revealing judicial attitudes, when we will see how the courts have responded to some of these conditions. Now, a number of these conditions, I think, will sound familiar to Thai readers and Thai listeners, to you. They'll sound familiar because some of these conditions appear in your Protection of Children Act of 2015. But there's an important difference between the Thai approach and the British approach. In Thailand, these are the conditions to make the practice lawful, to make the surrogacy arrangement a lawful act. The surrogacy is lawful unless there's some criminal profits being made. And our conditions are not to the legality of the practice, our conditions are to the availability of the parental order. In other words, if you don't satisfy the condition, you cannot ask the court to transfer parenthood from the surrogate to you. So the conditions may sound similar from a Thailand perspective, but where they come in the legal process is different. So the first condition or group of conditions, and I think this reflects Thai law too, are contained in section 54, 1A and 1B, the pregnancy has to have come about artificially. If a surrogate becomes pregnant through sexual intercourse with the intended father cannot go to court and seek a parental order. The pregnancy has to have come about artificially. The thinking in 1990, the thinking in 1990 when this condition was first created, the thinking was by our politicians was that if we recognize a pregnancy through sexual intercourse, then this is not a true surrogacy situation. This is very akin to prostitution. And is not to be encouraged. I don't think that reasoning would quite be adopted today, and I think it always was quite weak. But what it does is to allow the Human Fertilization and Embryology Authority some control on how the pregnancy occurs. The second condition here, there has to be a genetic connection with one or both of the applicants for the order. And again, I think I'm right. This is also the position in Thailand. At the moment, if the genetic material born by the surrogate, it comes perhaps her own material and those of a sperm donor, but not the commissioning couple, then a parental order is simply not available. But that's not to say that the commissioning couple, the intended parents, will not be able to get the child. If the surrogacy arrangement goes well, they can always go to court and ask for an adoption order. To get the parental order, there has to be some genetic connection with one or both of the children. This is the condition that distinguishes the practice of surrogacy from the practice of adoption. It's the condition which makes the intended parents believe right from the start, this is our child, or this is my child, not somebody else's child. I think that's quite a weak argument too, but it's one that is generally accepted throughout the United Kingdom. There's a number of other conditions for making a parental order, and here's some more, and some cases on this slide. And what's important here is that this shows a judicial attitude. Ever since the 1990 legislation came into force, the judges have been supportive of surrogacy and the ease of transferring parenthood. They have interpreted, in other words, these conditions really quite broadly and liberally to ensure that a parental order is made. And you can understand, I think, the judicial mindset here. A parental order is only available after the surrogacy arrangement has been given successful effect to. Everybody is happy. Everybody is happy. The commissioning couple, the intended parents, they have the child. The surrogate mother is happy for them to have the child that she bore. And now they go to court to ask, let's regulate, regularize, make official this situation on the ground where the child has been brought up by the intended parent. And the judges are more than willing to do so. And the result is that they interpret the legislation surprisingly widely. So, for example, Section 54, subsection 2 says that when a couple seek a parental order, that couple must either be married or civil partners, or in an enduring family relationship. Enduring family relationship. This is designed to deal with unmarried couples. In the first case mentioned there, the 2020 case, Ray A. surrogacy in 2020, the court held that that condition was satisfied, even although the couple had separated after the application. They were living together when they made the application, but then they separated and were living apart. And the court said they're still in an enduring family relationship, so we'll make the order. The most recent of these cases, it was decided earlier this year in 2022, a case called X against W. And this condition, was held by the court to be satisfied. The couple were in an enduring family relationship, even although one of the couple had died. The court is trying to regularize the child's situation, do all that it can do to ensure that the child stays with the intended parents. It's very odd to say there is an enduring family relationship between one person and a dead person. It's very odd to say that, but the court held that that condition is satisfied. Another condition in section 55.4, the child is living with the couple. The child has to be living with the couple when the order is made. And all these cases I cite, the couple have separated, but nevertheless, the court has held the child is still living with the couple so long as the child has a relationship with both the couple. You can live with one of them 1 week and live with the other week. That's an unusual interpretation of living with anyone. Section 54.5, both of the couple have to be over 18. The intended parents both have to be over 18. It's worth noting, I think, that in Scotland the age of marriage is 16, though it's 18 in England. And then the final two conditions, the legal parents must consent. Now, the legal parents, the original parents, are of course the surrogate, and if she has a husband, her husband, they must consent, and there's no exception. If the surrogate withholds her consent to the granting of the parental order, then no parental order is available. But the intended parents can still go to the court and ask for an adoption order, because there's ways around the consent issue with adoption. And the final case listed on this slide, C against S in 1996, that's the only Scottish case on adoption law that we have. Well, we now come to the condition which annoys me the most, or should I say the conditions that annoy me, but the judicial approach to it annoys me the most, because the judges have been most brazen in simply ignoring the words Act of Parliament. And this is something judges in the United Kingdom very seldom do, but they have done so here. They've effectively rewritten the legislation in order to make it easier to apply for a parental order. British judges do not have the power to rewrite British legislation. That's a general constitutional proposition, but they have done so in this case. This is the time limit issue. The 2008 Act says quite clearly that the application must be made. That's an imperative. It must be made within the period of 6 months, beginning with the day on which the child is born. In other words, you've got 6 months in order to make the order. And there is good policy reason behind this. the child is in a vulnerable position when the child is being brought up by the intended parents who actually have no legal relationship with that child. That's a vulnerability for the child. So it's good social, public, and legal policy to ensure that the order is made as quickly as possible so that the people bringing the child up, in fact, also have the legal right to do so and the legal power to make all the important decisions in the child's upbringing. So you've got 6 months to do it. The legislation is quite clear. However, in Re X, a child surrogacy time limit, this was decided by the Family Division of the English High Court in 2014, the time limit was effectively ignored because the couple in this case didn't know about the law. Most people do not know about the law. They had never heard of the concept of a parental order. Their surrogacy arrangement had gone well. They were bringing up the child. The child was now 3 years old. So you're 2.5 years after the time limit. And this couple who are bringing up this get told by somebody, but you should have got a parental order. They said, we didn't know. So they went to the court and said, we'd like to apply for a parental order, please. And the judge looked at section 54.3 and said, yeah, but you've got to apply within a period of 6 months. But if it's in the welfare of the child for the order to be made, then Parliament could not have intended to prohibit it. Parliament could not have intended to prohibit me making an order that is in the benefit of this child. So I'm going to make the order. And he did so. And since then, there have been numerous cases in which older and older children, years and years after the 6-month limit has gone by. And the most recent case is a case called X against Z, decided earlier this year in 2022. There, a parental order was made over an adult, which, by the way, is something not possible with adoption. But the parental order in this case was made over an adult who'd been born to a surrogate in the United States of America in 1998. Even in adulthood, it makes a difference because there might be inheritance issues. But this is the case in which 20-odd years had gone by after the 6-month limit, and the court again said it doesn't matter. A rather more contentious issue in which the British judges have said it doesn't matter is money. Because the condition for the parental order being made is this: no money or other benefit has passed except reasonable expenses. And reasonable expenses, you can pay for the mother's health care during her pregnancy. That would be a reasonable expense. But no money or other benefit has to be made unless authorized by the court. In other words, the legislation is not being rewritten by the judges here, but the legislation is giving the judges the ability to ignore the fact that money has been paid, or to authorize money. And I've listed a couple of cases. There have been lots of cases because usually money is paid, or at least if a British couple go abroad, money will be paid. In the United Kingdom, virtually nothing, but if they go abroad, they will be required to pay money. And the court, when they come home with the new child and ask the court for a parental order and tell the court, we paid 25,000 euros or 50,000 euros or whatever, the court will authorize it under then the parental order to be made. There is no case in which authorization of payments has been refused. It's not quite a rubber stamp, but it's getting fairly close to that. And I think there's a number of important points to be made here, particularly the fact that money arises when the couple have gone abroad. When the couple have gone abroad. Commercial surrogacy is prohibited in the United Kingdom, but it's not prohibited in many parts of the country. It is now, of course, in Thailand, but it's not in India or Russia, though British couples are not going to Russia at the moment. In India, there's quite a thriving surrogacy practice, but we have to be aware that only around, if you go to India for your child, only around 1/10 of what you pay will actually go to the surrogate. The rest of it, of course, goes to the for-profit agency. And that will create all sorts of alarm bells, ethical dilemmas, which the British courts so far have simply refused to deal with. So that is the current law in the United Kingdom. I want now to talk just much more briefly about the more general situation across the European Union. And the first thing to notice about the European Union is it's made up of now of 27 different countries, and each of these countries adopts a very different approach. There is no unified approach to surrogacy across the EU. Some embrace it, and some very vigorously, some countries very vigorously reject the practice of surrogacy. So it's permitted, for example, in Czechia, the Czech Republic, but it's criminally prohibited in Italy and Germany, Poland, Spain, Finland, and Hungary, and of course, no parental transfer can be permitted. There are some countries where surrogacy itself is prohibited, but if it happens, as it does, then there can be a parental transfer that is permitted via the adoption route. And France, Austria, Estonia, and Lithuania, I think, fall into that category. Surrogacy is allowed, but only if not commercial. There's a whole group of countries there. There's a whole group of countries with no specific rules governing surrogacy at all. The law is simply silent on the matter. And Bulgaria, incidentally, the Bulgarian parliament is this year considering legalizing and regulating surrogacy. So there's a great mishmash of approaches across the European Union. And this has one very important consequence. Because there is effectively free movement of people throughout the European Union, what this means, it's very easy if you live in a country that prohibits surrogacy, there is nothing to stop you from going to another country, either within the European Union or indeed out with that country. There's nothing to stop you going to the other country, entering into a surrogacy arrangement there, and hopefully being able to bring the child back to your home country. It doesn't always work, as we'll see in a moment or two. But free movement means that the differences between the countries that really have set their face against surrogacy and those member states of the European Union which accept surrogacy, the differences can be got over so long as you've got the money to do so. And here's an important point, the bottom issue on this screen. the European Court of Justice declared in 2020 that if parenthood is recognised in one member state, then it has to be recognised throughout the EU. So if, for example, you go to the Czech Republic, you live in France and you go to the Czech Republic, enter into a surrogacy arrangement there and are recognised by Czech law as the parents of the child, there's an obligation to recognise your parenthood as well. So within Europe, because there's so many differences, this actually encourages international movement of people. And we've seen this in Britain, which sadly is not a member of the European Union. But in Britain, couples who don't use a British surrogate, who have the money to go to other countries, the United States, previously Ukraine and Russia, India, countries like that, British couples do quite frequently go abroad and then bring the child back here. And that, of course, raises the very fact there's a lot of international movement of people here. That raises another challenge, one that is so far insolvable, which is the international regulation of surrogacy. And at the moment, there is no international regulation of surrogacy. And that in itself, I think, is interesting if you compare this with the Hague Convention on the Protection of Children, Cooperation and Respect of Inter-Country Adoption, the Adoption Hague Convention, in other words, which has been ratified, I think, by over 90 countries. There's a very strong prohibition in the international regulation of adoption. There's a strong prohibition on paying money. The dangers of selling children, of trafficking children, was very much at the forefront of the Hague Convention, the Hague Conference, when it was negotiating a convention for the protection of children. And notice again, it's called the Protection of Children and Cooperation in Respect of Inter-Country Adoption. It's about protecting children. International regulation of adoption is essential to give proper protection to all one's children against exploitation, child selling, and child trafficking. And by and large, this has worked quite well in adoption. Surrogacy has no international regulation. And I think the reason why we are unlikely to see much in the way of international regulation in the future, I think the reason is that there is no common ground. Different countries have very different approaches. Even countries economically and politically so similar as the countries that make up the European Union, as we have seen, even these countries cannot agree the appropriate response to surrogacy. So if you widen that out to the whole world, every country will have a very different approach, a very different understanding of whether surrogacy is an acceptable act, an unacceptable act, something we just have to put up with, something that requires regulation. There is simply no agreement. Some countries will prohibit all forms of surrogacy for everyone. Some countries prohibit non-gestational surrogacy when you're using other than the genetic material of the surrogate. Some countries allow surrogacy only for medical reasons. Some prohibit commercial operations, as I think Thailand does now, and the United Kingdom. And some countries are happy to allow payments. Some countries require court involvement in transference of parenthood. The United Kingdom does. Others recognise intended parents as parents automatically, which I think is the situation, if limited, in Thailand. So because there is so much international disagreement, there is no common ground in the way that there was with adoption. Most countries in the world understand adoption, understand this is good for children if it needs to happen. With surrogacy, some countries think this is never good for children, and other countries say, well, the child's not the issue. Some countries say the issue is the parents. So I want to look at some of the ethical debates that underpin all of these disagreements. And I've identified some of them on this slide, and doubtless there are many, many more. The first one is surrogacy too close to prostitution. This was a feeling in the United Kingdom in 1985. It was just a bit too close to prostitution. It was a woman using her body for purposes other than natural childbirth, in which she's going to bring up the child. She's likely to get paid for a consequence that normally follows after sexual intercourse. So is it close to prostitution? I think this ethical debate is very old-fashioned and has very little purchase today. Certainly in the United Kingdom, we do not see the surrogate as doing anything remotely close to prostitution. It's a generally altruistic act. In other countries, of course, she will be paid, but she's not being paid for sex. It is different. There is something inherently, fundamentally different between the sexual act and bearing a child. Is surrogacy too close to baby selling to be acceptable to the law? This I think is an argument, a proposition that does still have real resonance, particularly in the international situation. It's very, very difficult to draw a clear line between the altruistic act of bearing a child for someone else and giving away your child in return for payment. The United Kingdom and Thailand, of course, tried to address this issue by saying only on a non-profit basis can this be permitted, only on a non-profit basis. But in the United Kingdom, as we saw with the payment slide, that proposition tends to be less powerful in the eyes of the judges than the child is with the intended parents, is currently being brought up by the intended parents, and it would be very harmful for that child to remove that, to break that existing bond. So it's the issue, I think, which still makes most people hesitate about fully embracing surrogacy, that the connection with baby selling might be too much to bear. Some people argue that the transference of parenthood by the law is unnatural. Parenthood is a natural thing. The woman who gives birth to a child is the natural mother, and whatever the law says, she will always be the real natural mother of the child. And they would go on to argue that parenthood can only be transferred in extreme situations, which are usually covered by adoption, child abuse and child neglect. that sort of thing, where you're removing a child from a neglectful or abusive family and allowing somebody else to bring up the child. I think the point with adoption, and even without adoption, but certainly with adoption, the point is that the legal definition of parenthood is always artificial. It's always artificial. And we see this with maternity, motherhood. Once IVF was created, it was developed, it suddenly became possible for a child to be born with two mothers, one who provided the genetic material and one who provided the womb, the gestational environment. It's not a natural thing to say the mother is one or the other. It's a human choice. It's a legal choice. And in the United Kingdom, we chose the woman who gives birth to who bears the child, who is pregnant and then gives birth. That's not a natural choice. It's a legal choice. So my own view is that the legal definition of parenthood is in itself an artificial human choice. If surrogacy is acceptable, and whether it's acceptable or not, it happens, is it right for the law to limit who can benefit? Should it be limited, as Thailand does and the United Kingdom did until 2008? Should it be limited only to married couples? Should it be limited to those of a particular nationality, which again, I understand Thailand does limit lawful surrogacy to Thai nationals. Now, clearly, I think that is motivated by a desire to interrupt the international trade of surrogacy and children. So that might be justified. And in the United Kingdom, we don't adopt nationality as our approach, but for a parental order, we do have a domicile requirement. You have to be domiciled in the United Kingdom to get a parental order. So that limitation is I think justified. Limiting it to married couples, that seems to me to make a number of assumptions about what is good for children. And these assumptions have been increasingly challenged. Certainly in the United Kingdom, it's no longer believed that the only good and safe environment to bring up a child is with married couples. We simply don't believe that anymore. Should the benefit of surrogacy be limited to those over or indeed under a certain age? The British people who go abroad for surrogacy tend to be older, tend to be the sort of people that a surrogacy agency, a charity, a non-profit charity, won't be very encouraging about. Should we exclude gay and lesbian people? Again, this is based on making assumptions about what is good for children, which in the United Kingdom, at least, and many other countries in Europe, we just don't believe anymore that it's necessarily bad for children to be brought up by gay and lesbian people. Should we exclude those with criminal records? Anyway, these are a number of the ethical challenges. I just wanted to mention a couple of cases in which ethical issues have been in front of the judges and how they have responded. Here we have on this slide two British cases, two English cases, plus a case from the European Court of Human Rights. Whittington Hospital Trust against XX. That's quite an interesting case. That's a case for damages for medical negligence. It's a case of tort rather than the family law. And this woman went into hospital. The doctors were negligent in her treatment, and it left her infertile. The hospital accepted it had been negligent, and the hospital accepted it was due the woman some damages. The question before the court was the extent of these damages, because once she became infertile, this woman went to the United States of America and paid for a commercial surrogate to bear a child for her. And when she came back home with the child, she wanted to recoup these costs as part of her medical negligence claim. And the case went all the way to the United Kingdom Supreme Court. And by then, by the time it got to the highest court in Britain, the issue was, is it contrary to public policy to give damages to this woman, including for a commercial surrogacy, which of course is a criminal offence in the United Kingdom. And the court said, no, it's not. It's not contrary to public policy to give her damages on this basis. So even again, the money issue doesn't bother the British courts too much. Just in comparison, how they do things in Italy is very, very different. The Paradiso case, Paradiso against Italy in 2017 was a case decided by the European Court of Human Rights, a sort of pan-Europe human rights court. Italy is one of the countries in Europe that very strongly criminalizes anyone involved in surrogacy. It really does not like the whole practice of surrogacy. It's a criminal offence. This Italian couple were too old to adopt in Italy, so they went to Russia and they paid the surrogate. The surrogate said she would take the husband's sperm, impregnate herself. She became pregnant, she gave birth to a child. Then the Italian couple registered the child as their own in Russia without mentioning the fact it had been a surrogacy arrangement. So they were defrauding Russia as well as avoiding Italian law. They returned to Italy and the child was removed from their care on the ground that the couple had infringed Italian law by going abroad. They'd infringed Russian law by registering the child with false information. And also, one of the big shockers of the case was after a DNA analysis of the child, it was discovered it was not the husband's sperm that was used at all, but the surrogate's husband's sperm. And so she had been lying as well. Everybody was lying to everybody else. The child was removed into the care and protection system in Italy, and the Italian couple were prosecuted. And they claimed, they took this case to the European Court, claiming that this was a breach of their human right under the European Convention. And that claim was rejected by the European Court on the ground that they had no connection to this child. Neither of them, they thought the husband was genetically connected, but he wasn't. They had infringed both the law of Italy and Russia, and they effectively couldn't complain. Not quite so extreme as a more recent English case called Ray X in 2020. An English couple went to a country where surrogacy was illegal, where surrogacy was actually illegal, and they paid a surrogate in breach of that foreign country's law to bear a child. They paid her, and they came home with the child and applied for a parental order. And the question was, would it be contrary to public policy to make this parental order in the face of the couple's deliberate criminal actions? And the court again held no, it's not. And the British court made the parental order even in the face of deliberate criminality. So the end result here is that public policy are real ethical issues, and they tend not to bother the British courts. The British courts tend to say that the welfare of the child is effectively the only thing that matters. and the welfare of the child is nearly always served by leaving the child where it is with the intended parents, and then giving the intended parents the benefit of a parental order. Now, my final issue that I want to talk about, and the final challenge for surrogacy laws, is how should we change the law? And in the United Kingdom, there have recently been significant proposals to change the British law of surrogacy. These proposals come from the Law Commissions, the Law Commission of England and Wales and the Scottish Law Commission. As I said earlier, we have two different legal systems in the United Kingdom, Scotland and England and Wales, and two separate law commissions. These are bodies, quasi-governmental bodies charged with proposing improvements to the law. And sometimes in areas of the law where the law of Scotland is the same as the law of England, the two commissions come together. And this is what they did here in their surrogacy report, their surrogacy project. And they have used a consultation paper with some early ideas about how the law of surrogacy throughout the United Kingdom should be improved. Now, the first thing I want to point your attention to is the very title of this document: Building Families Through Surrogacy. Building Families Through Surrogacy. This is positive. This is encouraging. This is a title that embraces the validity of surrogacy. Surrogacy, in the very title of the Law Commission's work, surrogacy is something to be embraced and made easy and regulate properly. So it's a supportive thing. Now, this is very different from even the 1990 Act, where surrogacy was still something to be discouraged. Now it's something the law will embrace. I think titles are really important. I mentioned earlier, I think, that the title of the law in Thailand, Protecting Children, shows what it's all about. This title, it's all about building families, encouraging families to be built in this way. Now, the first thing I want you to note, the first issue is regulatory changes that they are suggesting. And they're building upon the work of the Human Fertilization and Embryology Authority. We have this body in existence already regulating the provision of IVF, artificial insemination, egg and embryo transfer, all the forms of artificial reproductive medicine. The authority exists. This is the obvious authority to take on a role in regulating surrogacy. And the Human Fertilization and Embryology Authority is going to be given the power to license surrogacy agencies. It's going to monitor the terms of surrogacy agreements. So it's going to look at each agreement just to check that it's not abusive or exploitative of either side. It's going to draw up a code of practice, which will have to be followed by surrogacy agencies. Agencies will still have to be non-profit, of course. The agency, the authority, will also maintain a register of origins so that people can have access to their own birth information. This is something that exists in our adoption legislation already. An adopted child can find out their own history. A child born through surrogacy will in the future be able to find out their own origins because a register will be kept. Surrogacy arrangements, however, will remain entirely unenforceable, and advertising will now after this new law comes into force, advertising will now be permitted. The next set of changes relates to parenthood, which is this parental order. The parental order means, the current law means you have to go to court and ask a judge to make an order to transfer parenthood. The new law will make parenthood transference automatic, and it will happen immediately on birth, so that there is no need for a court order. But this only works so long as a number of conditions are satisfied. And I will, in the next slide, list some of the more important of these new conditions. The surrogate will be protected because she'll be allowed to change her mind for up to 14 days after birth. So she gives birth, the intended parents will in law be the parents of the child, but it will be conditional for the first 14 days, and the surrogate can change her mind. So actually, I want to keep the child, and if she wants to keep the child, then the transference does not happen. And I'll come on to the conditions in a moment, but even if the conditions are not satisfied for this automatic transference, the existing parental order can still be sought. And even if that can't be sought, you can still go to the court and seek an adoption order. So finally, the conditions that have to be satisfied before there's automatic transference of parenthood immediately on birth, the intended parents will become parents, as is the case in I think, Thailand. This will happen in the United Kingdom after this new law comes into force, if the following conditions are satisfied. First, the surrogacy agreement has been approved by the Human Fertilization and Embryology Authority. It's really important that this authority has control over the reasonableness of the surrogacy agreement. Surrogate has not changed her mind within 14 days. I've already talked about that. There's a domicile or habitual residence requirement. One or both of the intended parents must be domiciled as habitual resident in the United Kingdom, otherwise this doesn't work. There still has to be a genetic connection. This was a matter of some discussion within the law commissions. There still has to be a genetic connection between the intended parents and the child. At least one of them must be the provider of the sperm or the egg, or both. But there will be an exception if, for medical reasons, neither is able to provide genetic material. All parties should be at least 18 years old. That reflects the existing law. The new law will demand medical screening, particularly for the potential surrogate, and it will mandate counselling about the implications of surrogacy for all parties, both the surrogate and the intended parents. All parties should have independent legal advice before entering the agreement. And interestingly, the parties will be subject to criminal record checks. I'm not entirely sure what the consequence of that will be. I don't think the new law is likely to say, if you've got a criminal record, you cannot become a surrogate or you cannot become an intended parent. It's more likely, I think, to say, it's more likely to be a disclosure issue. You have to disclose to the other party if you've got a criminal record. And another thing the law commissions are working very hard on is to list what might be legitimate payments. Things like lost earnings of the pregnant woman, maternity clothes, perhaps pain and inconvenience of pregnancy and childbirth, compensation for death if the pregnant woman dies during childbirth, which does still happen occasionally, who compensates for that? And the issue they're still struggling with very, very deeply is the issue of fees. Beyond expenses, should the surrogate be paid a salary effectively for 9 months' work of bringing up the child? So that's still an issue which the law commissions are currently exploring. That I hope gives you a flavour of the new proposals. We're likely to get a full report towards the end of this year, and we hopefully we'll get legislation within the next couple of years. Ladies and gentlemen, that is, I think, all that I need and want to say this afternoon about the various challenges of surrogacy in the United Kingdom and elsewhere. And I hope that you have been able to follow what I've been saying, and that you have found it interesting and informative. So I'm happy to take any questions that anyone has, but until I get such questions, I just want to thank you for paying attention to me this afternoon.
Thank you very much. Actually, there are questions now, 2 questions typed in Thai in the chat box. So if you don't mind, I will translate it for you.
Yeah, please.
Okay, so the first questions, when intended parents want to operate a surrogacy, but they are in the country that bans surrogacy. So they fly to another country where surrogacy is legalized and pay for surrogacy operation in that country. Then where should be the country that this couple register the child officially? That's the question.
Yeah, it's a good and difficult question, because every country in the world has its own rules for registering the birth of a child. The general proposition, and if most countries adopt this approach, is that where a child is born will determine where it is registered. And this is why when intended parents decide to go abroad, they have to choose their country carefully. If they go, for example, to California in the United States of America, that country requires they register there, and Californian law will say they are automatically the parents of the child. So that deals with the registration problem, the registration issue, but it does not mean that the United Kingdom will recognize that registration. They will not recognize that conferral of parenthood. And the United Kingdom, in fact, does not recognize such a transference of parenthood. That is why people have to come to the British court and ask for a parental order. Otherwise, they could just say, "Oh, we're the parents, we've got the Californian registration." So registration only gets you so far. It's only recognized in the country of registration. And then you get a difficult international private law issue of how can a parenthood recognized in one country be taken to another country. Within the EU, the issue is simple. It's straightforward. If you're recognized in Spain, for example, if you're recognized in Spain as the parents of this child because you've registered the child there, then you will be recognized as the parents throughout the European Union. So it's easy there. But any other country relationship recognition of parenthood becomes very, very difficult.
Thank you very much for your answer. Then moving to question number 2, typed in the chat box. Is there any law limiting the number of surrogacy operations that can be made to one surrogate mother? And vice versa, is there any law limiting the number of surrogacy contracts or the number of children one intended couples can make? Thank you.
Again, it's an interesting question. The simple answer in the United Kingdom is no. There are no such requirements, either in terms of how many children the surrogate can have, or how many children the intended parents. And I understand also in Thailand there was an issue some years ago of a potential intended father having dozens of children. So it is a real issue, and the law commissions, in discussing their new proposals, explored these issues. And the first issue was should there be a requirement that the surrogate already has a child? And I think I'm right that this is something, again, that exists in the law in Thailand, that the surrogate has already to have had a child before she acts as a surrogate. That was one of the issues the Law Commission considered for Scotland, for the whole of the United Kingdom. And another issue was, should there be limits on number of children that the surrogate bears? And they explored these issues, and they held public hearings about these issues. They decided, I'm pretty sure they have decided at the end of the day not to impose any such requirements on the number of. Interestingly, I attended a couple of the public discussions that the law commissions had, and one of the issues that the medical profession has put forward very, very strongly is that the surrogate mother should already have had a child, because only then will she be in a position properly to understand the consequences of pregnancy for her. But again, I should be surprised if that came into our law.
Thank you. So I think maybe the last question. This is my own question, actually. So how is the parental order in the UK different from the court order that the biological father filed for becoming legal father of the children born out of wedlock in the UK? How different is that?
I'm sorry, could you repeat that question? There was a little interference as you were speaking.
Yes, okay, so how is the parental order in the UK different from the court order that the biological father filed for becoming legal father of the children born out of wedlock in the UK?
It's different in this way. For the father seeking a court order saying he's the father of the child born out of wedlock, effectively that is a declaratory judgment. He is asking the court to declare something that is true. Don't change anything. I am the father. Here's the evidence. Now declare me to be the father, so that I have a court order that I can use as proof in whatever context I need that for. So it's not changing anything. It doesn't change who is father. It just declares it reveals. The parental order, on the other hand, changes something. It changes something. It makes somebody the legal father of a child who is not in law the father of that, even if his genetic material has been used. If it's artificial insemination to a married woman, the surrogate is a married woman, it is her husband who is the father of the child in law. So the parental order changes something, whereas a declaration of parenthood to an unwed father doesn't change. It simply declares.
Thank you. So I think that's one more question from Dutch Tanyanutantikun. Do you see the question in the chat box?
Yeah, I'm just looking at it now. Thank you. Bible option. So the question is, I'll read it out.
Okay.
I think that would
Okay.
be
Thank
for
you.
me and our readers, our listeners. What's your take on multiple parenting? Do you think this is a viable option to solve the conflict between surrogate mother and genetic intent? It's common in Brazil, and there's some consideration about this in the Netherlands. How do you see the unfolding of the option in the UK or the EU in the future? Multiple parenting. I'm assuming what you mean by this is a recognition by the law that a single child can have more than two parents. There's a few jurisdictions in the world that are gradually recognizing that this is so. And in some senses, what it is doing is reflecting reality. We see this particularly in the gay community, when you have a lesbian couple and a gay friend who has provided them with sperm. And the lesbian couple are bringing up the child, but the gay friend is involved in the child's upbringing. The reality in that situation is this child has more than two parents. The law in most countries in the world at the moment very strongly limit parenthood to two and not to multiple things. I think in the surrogacy situation, to directly address the question that is asked, I don't see that multiple parenting will help at all, other than for a very, very short period, maybe this 14-day period after birth, immediately after, when the surrogate who has given birth, she needs time to fully make up her mind, and the intended parents, in that very short period, perhaps multiple parenthood serves, recognizing that this child has at the moment three parents, serves a purpose. But I suppose my concern with it would be in what context would the issue be relevant? Let's say one of them dies, and there's inheritance rights. Does this and all three of them die? Does this child get inheritance rights from three people? That seems a bit fortuitous to me. More likely, it might be the child is needing some medical treatment that somebody needs to consent to. Probably two parents are enough, and if you've got a third parent, that gives more room for a dispute in a potentially very time critical situation. So I accept that in some circumstances multiple parenthood reflects the reality, but in the surrogacy situation, my feeling is that it would create more potential problems than it would solve. Thanks. Good question. Thank you.
Thank you very much. That's a very interesting question and answer also. So Pete, thank you very much for your insights and perspectives on surrogacy law. We really appreciate your time, your contribution, your insightful lecture and answers today. Also, thank you all for joining the seminar today and asking lots of interesting questions. Before the end of the seminar, I would like to invite Justice Anosha Chiwitsopon, President of the Court of Appeal for Specialized Cases, once again to kindly give closing remarks. เรียนเชิญค่ะ
คดีชำนาญพิเศษดร.กิตติวัฒน์จันแจ่มใสอาจารย์ประจำคณะนิติศาสตร์มหาวิทยาลัยธรรมศาสตร์อาจารย์แคนเนธแมคเคนซี่โนรีอาจารย์ประจำคณะนิติศาสตร์มหาวิทยาลัยสเตชคลายและคณะทำงานของแผนกคดีเยาวชนและครอบครัวในศาลอุทธรณ์คดีชำนาญพิเศษที่ทำให้เกิดการบรรยายในวันนี้และขอขอบคุณผู้รับฟังการบรรยายทุกท่านดิฉันหวังเป็นอย่างยิ่งว่าการบรรยายในวันนี้จะทำให้ผู้รับฟังการบรรยายได้รับความรู้เกี่ยวกับปัญหาและการปรับใช้กฎหมายขัดกันในคดีครอบครัวของประเทศไทยและได้รับความรู้ความเข้าใจถึงกฎหมายอุ้มบุญของสหราชอาณาจักรและสหภาพยุโรปสามารถนำความรู้ที่ได้รับในวันนี้นำไปประยุกต์ใช้ในการพิจารณาพิพากษาคดีเยาวชนและครอบครัวและพัฒนากระบวนการยุติธรรมสำหรับเด็กและเยาวชนให้มีประสิทธิภาพยิ่งขึ้นบัดนี้ได้เวลาอันสมควรแล้วดิฉันขอปิดการบรรยายให้ความรู้เพื่อเสริมสร้างมาตรฐานการอำนวยความยุติธรรมของศาลอุทธรณ์คดีชำนาญพิเศษแผนกคดีเยาวชนและครอบครัวณบัดนี้ขอบคุณ Thank you very much สวัสดีค่ะ
อย่างเดียว